We're going to get started with today's workshop and our presenter, Trent Pettus. Trent is a great contributor to GPAR. He was a VIP in 2019, picked up a cool award from our president, Chris Summers, for all of his contributions to the association. And he is back in Philadelphia from sunny, warm, palm tree in the background, Florida. So he's back with the rest of us. Trent, good morning.
Good morning, Matt. How are you?
Great, great.
Good morning, everyone. Good morning. Good morning. All right. Well, let's get started. I'm sure Matt said that this is interactive. So if you have questions, just interrupt. If you want to add anything, let's make this educational, fun, and so just, don't wait to the end to ask questions. Just ask when you hear something you don't understand or you want to add something, then just do it. We're going to go through the buyer agency contract, every paragraph, and hopefully we will all be better having done it. And one of the things that I've always believed, and I've been a broker for many years. I'm a broker in Pennsylvania, in my office here, Delaware, and I have an office, opened an office in Fort Lauderdale a couple of years ago, right during the pandemic. Actually, I got a broker's license. I bought a condo there 3 years ago. Decided I may as well get a broker's license, which I did, and open an office there. So I go back and forth to Florida, back here. But these contracts, we know they are employment contracts, buyer agency contract, a listing contract, and these are things that we work with every day. That's the reason I do these, and as well as agreement sale seminar, because we really should know what's in these contracts. You don't have to be an expert on anything. You don't have to know every single thing there, but let's just get a good idea. So when you're sitting down with the buyer, or you're sitting down with the seller, or with a buyer or seller or whomever, you want to have a good idea of what you are talking about and what's in these contracts, because you don't want a buyer, in this case, asking you questions that you just don't have the answer to. If you don't know the answer, you ask someone. I never felt embarrassed to say to a client, I don't know. I never said to a client, I never answered a question when I didn't know the answer and hoped I got it right. I always said to a client, when I was a newer agent years and years and years ago, I would say, I don't know the answer, but I'm only one phone call away from the answer. And that's what I train agents to say or to do, not to think that you need to know everything, even experienced agents. I don't know everything, and I'm sure there are some experienced agents here who don't. So we help one another. And so if you don't know something, that's fine. Don't ever give an answer to a client. Don't answer a question you don't know the answer to, because when they realize it's incorrect, then you lose all credibility. But having said that, let's just get started. Any questions, any comments before we start? If not, let's start. Let's start with the consumer notice. Consumer notice, the first document, obviously, you give to a client, to a customer, client, anybody, the first time you have a substantive conversation. And you have all the documents, I'm assuming. Everyone has the documents we're going over? Does everyone have the documents?
Yes.
All right. The consumer notice, just take a look at the consumer notice. You have to give a consumer notice when you have, well, let's look at it. It says, in an effort to enable consumers of real estate services to make informed decisions about the business relationships they may have with real estate brokers and salespersons or licensees, the Real Estate License and Registration Act requires that consumers be provided with this notice at the initial interview. Initial interview means where a substantive conversation about real estate occurs. Substantive, not what is a zoning classification. If someone called, if you're on the phone or you're in person with someone and they're asking you about the number of bedrooms, it's not a substantive conversation. You don't have to give them a consumer notice. I think it's a good idea to give it to them no matter what conversation you have. But but you have to give a consumer notice when you have a conversation with me. All right, a conversation of where information that is not public. I mean, the number of bedrooms, the zoning classification, all of that information is public. So if I call, I get a phone call saying, hey, what's the zoning classification? I say it's RS5A. Well, I don't have to give you the consumer notice at that point. But when you start giving me information that only you would know, that I have no idea about, then I need to stop you, give you consumer notice. Obviously, if we're on the telephone, I can email it. There are ways I can get it to you, but if not, I have to give you an oral consumer notice, and I think that's also in your package. But just remember this, and a lot of agents don't maybe forgotten this consumer notice. If there is no transaction occurs, you must keep a copy of this consumer notice for 6 months. Remember that you, the agent, must keep a copy of this consumer notice for 6 months. If it becomes if there's a transaction that results from this, then your broker there will be a file created, and your broker has to keep it for at least 3 years. But if it's just someone you showed a property to, and you gave them the consumer notice, and you never saw them again, you should have this consumer notice, and you must keep it for at least 6 months. All right. So obviously the consumer notice is there to let the potential client know what the different business relationship choices they could have with you, the agent, the licensee. Obviously, if you're a seller's agent, you would be representing the seller. Today, we're talking about a buyer agents. So if I'm the buyer agent, obviously I have to look out for your best interest. I'm going to enter into a contract with you to find your property, to do my best to find whatever it is that you're looking for. I obviously I could be a dual agent too. If so, when you go over this, you say, okay, you're a buyer, I would be your agent. But if I'm showing you properties that where I am also representing the seller, then I'll become a dual agent. Not everybody wants you to be a dual agent. I would say of all the transactions, I'd like to think I did over 1,000 transactions in my career. I would say maybe 2 or 3 people said, I don't want you to be a dual agent. So that, is rare, but it will happen. So when they say, oh, wait, no, I don't want you. You mean you could represent both of us? Well, isn't that a conflict? Well, in some states, there's a conflict. We're talking about Florida. In Florida, it is a conflict. It is against the law to represent both the buyer and the seller in the same transaction. You can represent one or the other, or you can be a non-agent for both. But you can't represent the buyer and the seller in the same transaction. Obviously, in Pennsylvania, you can. The only thing you have to have is disclosure. You must get written consent from both parties that will allow you to represent both parties. You have to have written consent. It can't be oral consent. It has to be written consent from both parties that says, I'm allowing you to represent both parties in this transaction. And there are 2 ways, of course, you can be a dual agent. Some new agents forget this. You could be a dual agent if you, the licensee, the salesperson, is representing the buyer and the seller in the same transaction. That's the clear-cut one. But you're also a dual agent if you're a broker, the company. If you're with RE/MAX, and RE/MAX represents a buyer and RE/MAX represents a seller, you represent because of every contract. Remember, every contract between the company and the seller, between the company and the buyer. So if the company is the same, in this example is RE/MAX, then a RE/MAX, let's say RE/MAX first, then you would be a dual agent, even though you represent one party and someone in your office represents the other. The dual agent because RE/MAX first, in this example, represents both parties, the buyer and the seller, because contracts belong to the broker, the company, not to the individual. Any comments, any questions? And if not, designated agency. Some companies now are moving to designated agency to avoid dual agency. Designated agency allows a company to designate someone to represent the buyer's interest and another agent to represent the seller's interest. Because they are designated agents and they should not discuss anything about this file with anyone other than the broker in this case is the dual agent. But well, let me back up again. Let me back up a second. If you're a seller's agent and you represent the seller in the transaction, everybody in your office represents the seller. If you're a buyer's agent, everyone in your office represents the buyer. If you're a dual agent, everyone in your office represents both parties. But if you're a designated agent, the other agents in your office represent no one. The broker is a dual agent, you would be the designated agent for either the buyer or the seller. And then obviously they both have to be, it has to be an in-house deal in order for it to be a designated agent. And in a designated agency situation, you're not speaking to anyone about this transaction outside of the broker. You're not talking to any of your colleagues in the office because they cannot know anything. Those files have to be accessible only to you and the broker. They can't be open to any and everybody in the office. And then, of course, a transaction licensee, that is a non-agent. You represent no one. Transaction licensee, you simply do paperwork. Someone comes to you and says, hey, I have a lot in Brewerytown I want to sell to my brother for 100,000. Can you write it up? He's going to put down 10,000. We're going to close it mid-April. You do paperwork. You don't give any advice or consent. You don't say to them, hey, I think that's a little low. I think that's too high. Or I think you should do this. Or I think, no, you just do the paperwork. You're a transaction licensee. You simply do paperwork and you fill in the blanks and you tell them, you ask them what goes in this blank and they tell you. Don't give them advice. Any questions, any comments? If not, I like when people talk, all right? So talk to me because I never know if you'll hear me or you're listening, you care, you don't want to be here. So let's talk. Yes. Does someone say something? All right, now let's go on to the buyer agency contract, the buyer agency agreement, whatever you want to call it. Listen, this is an exclusive right to sell contract. I never could figure out why they don't call it an exclusive buyer agency contract. This is an exclusive buyer agency contract. What does that mean? And this is what most people use. If you sign an exclusive buyer agency contract with a buyer, it means that this broker, this buyer, there has hired one broker or one company to help him or her find a property, and that if this buyer locates a property during the term of this contract, that broker has earned the commission. Doesn't matter if that buyer finds a property on his own, his or her own. If it does not matter how they come to purchase this property, or it could be a lease, but we're only going to deal with buyers today. How they come to buy this property, you have earned a commission. This obviously is the best type of contract for an agent, because I never want to compete with my clients. If I know that I am the person, I will be compensated because I will locate a property for this client. I don't want the client having multiple, well, I'm not going to say that because you may want to do that. So let me back up. But a buyer agency contract, one broker is hired to locate a property for this buyer. And no matter who locates the property during the term of this contract, the commission is earned. All right. And a non-exclusive buyer agency, and I don't have a copy, it's not in Canvas, but you can look at that. A non-exclusive buyer agency means just the opposite. You can hire as many brokers as you want to help you locate a property. The broker or that finds a property that you purchased during the term of this contract is the broker who earns a commission. But if you, the buyer, locate your own property that you purchased, then no one would earn a commission. So I think most of us will probably agree that the exclusive buyer agency is probably the better one to have, but everything in real estate is negotiable. Maybe you will use the non-exclusive. I can see there are some situations where I could see when you might want to use a non-exclusive buyer agency. We'll talk about that in a minute. But let's look at the buyer agency agreement. Again, it is an exclusive buyer agency agreement. First, broker, that's obviously the name of company, right? The company, write the whole name. And I just said a minute, Remax. Your company's name is not Remax. It may be Remax First, or maybe Remax Philly. Whatever is on your license should be. These are contracts. These are legally binding contracts. You need to fill them out correctly. The name of your company, and I've seen a lot of sloppy agents in my days and sloppy contracts. They've put Remax, they've put Weichert. Well, it's not just Weichert, it's Weichert something. So the name of the company, the license number of the company, you will know that, the address of the company, full address, the main phone number to the company. And then on the right-hand side, the licensee, your information. if you are working with another, if you have a licensee or co-salesperson who you're working with, their information should go on this as well. It should be both of your information, not just one. Put the, obviously your name, if it's someone else working with you, their name also, your license number, your direct phone number, your cell number, probably going to be the same in this case, a fax number, and your email address. And the buyer's name. Make sure you list all the buyers, because you want to make sure that each one is fully bound to the terms of this contract. If you have multiple buyers, all names, full names. If they're junior, senior, put their full names. Again, this is a contract. The buyer's mailing address, their phone number, email, fax. Just all the information, because you're in the event that you ever needed to contact the buyer, sometimes that happens. A year later, you want to have as much information in your office. We want to have as much information as possible if they ever needed to get in touch with this client, and you may no longer be in that office. Buyer understands that this buyer agency contract is between the buyer, the broker, and the buyer. What does that mean? If you, the agent, go to another office, you don't take this contract with you, because this contract belongs to the broker, the company. It does not belong to you. You are an agent. You are an agent for the company. The contract, again, is between the company, this buyer. So if you decide to go from one office to another, unless your broker allows you to take this contract or this client with you, this client stays with the original broker. All right. Buyer, does the buyer have a buyer agency contract with another broker? Important question. National Association of Realtors requires that we ask this, because you need to know if this person who you're about to enter into a contract with is already under contract with another company. You want to know that. That should be one of the first questions we ask. Do you have a buyer agency contract with another broker? If it's yes, it should pause. All right. No, you're fine. You go on. But if it's yes, you need to find out, well, wait, why? Because, and I remember once when I asked that question, they said yes. I'm like, whoa, and they said to me, well, my contract expires in 2 days. I'm not going to renew. I mean, I don't want to renew the contract with the original broker. I want to hire you to start representing me when my original one expires. In that case, you would put, if you see, let's go down where it says start date. In that case, if the contract starts when signed by the broker and the buyer, the contract starts when signed by both parties, unless otherwise stated here. In that case, we put the date, which was 2 or 3 days later. But if you leave that blank, then the contract starts the date that this contract is signed. By the way, it's always best to let the buyer sign the contract first, and then you sign it after you get it back. That way, you know the date of this contract. You know when, you know the execution date, because you don't want to be like, well, I signed it first. I gave it to the buyer. The buyer didn't date it, but I think he sent it back to me March 3rd, or maybe it was March 5th. It's easier. I like to keep things simple. Have the buyer sign it and date it. When they send it back to you, you sign and date it. You now know when this contract begins. All right. So let's go back up. So do you have a buyer agency contract with another broker? If there is, now here's one other thing. If, let's say, a buyer, and I've even seen this situation, a buyer says, yes, I have another exclusive buyer agency contract with another broker, but I don't like that broker, so I want to enter one with you. And I've said that, you understand, an exclusive buyer agency contract means that you have to pay a fee no matter who shows you this property. If you buy a property during the term of this contract, you owe a commission or fee to that other company. Well, you will also owe one to me, to my company. So you may be on the hook for 2 commissions. I don't recommend that you go sign multiple exclusive buyer agency or multiple buyer agency contracts at all. So buyers need to understand that. In that situation, I said, no, you wait, you can call me after this is over, but I'm not going to enter into an exclusive buyer agency contract with you when I know you're under an exclusive buyer agency contract with someone else. All right. Any questions, any comments? You all there? You sure you're listening? Somebody say something. Say boo.
Yes. Here listening.
All right. Are you learning so far? Am I boring you?
Yes, now we're learning.
I am
Learning a lot
boring you, you
today.
say?
Learning a lot today, Trent.
All right, good. All right.
Thank you
I
so
thought
much.
someone said I'm boring them. All right, let me go on there. So ask that question again. If it says they have one, you have to stop and you have to figure out why. And you may have to go talk to your broker. You may have to talk to an attorney. But the yes should create pause, and other questions. No, move on. Starting dates and end dates. It says, even though the broker's fee or portion is, well, first of all, no one has, everything in real estate is negotiable. So there are no organization, no GPAR, the National Association of Realtors, no one can say to either one of us when contracts should start, when they should end. They should tell us about what commissions or fees, because that would be an antitrust violation. But no association of realtors has set or recommended the term of this contract. Everything in real estate is negotiable. And broker and buyer have discussed and agreed upon the length of this contract. Even though the broker's fee or a portion of it may be paid by the seller or listing broker, buyer will continue to represent the interests of the buyer. Sometimes, I'm sure some of you who have been in business a while have come across this, where buyers think that if the commission is being paid from the seller or the seller's broker, then your obligation or your loyalty lies with the people who are paying your commission. Your loyalty lies with the person who you sign a contract with, not to the person who's paying the commission. Compensation does not determine agency. Contracts determine agency. So sometimes I've had to say, buyers, yes, the commission's coming from the seller side, but I don't represent the seller. I owe you those 6 fiduciary responsibilities that we all learned in class: obedience, loyalty, disclosure, confidentiality, accounting, and a reasonable degree of care. I owe you 6 fiduciary, and I call it an old car. I owe you 6 fiduciary responsibilities when you and I enter into a contract. My loyalties lie with you, not with the person who may be paying me. All right, you're the person I enter into a contract with. So if you have to explain that to a buyer, do so. Paragraph B says this contract applies to any, and here's the key word here, any. You said to any property that the buyer chooses to purchase during the term of this contract, any. That means everything, all properties. Any property that the buyer chooses to purchase during the term of this contract, buyer will not enter into a buyer agency contract with another broker that begins before the ending date of this contract. And as I said, when that buyer or potential buyer came to me, and when I asked, and he said, I already have an exclusive buyer agency contract, but I'm willing to sign a second one. And he was even okay if he had to pay 2, but I'm like, the contract says that you're not going to enter into 2 of them. You're only going to enter into, I'm not, until that one expires, I'm not going to enter into the contract. It would just be a problem. All right. And I don't like problems. I like solutions. This contract starts when you sign it, unless if it's going to start, if someone to start April 1st, you can sign this contract that's dated for April 1st. When does it end? It ends 11/59 or whatever date you say. You need to put a date. Please put a date. Please put a date. No end date may make this contract voidable or unenforceable. You need to put a date. Contracts can be open-ended. This is a contract. Put a date there. We've seen contracts with no dates, and they have been declared unenforceable or void. So you need to put a date. When does this contract expire? All right, put a date so you don't have a problem where a buyer saying, hey, I want out of this. You didn't put a date. I figured I could just, since you didn't put a date, I can just terminate it whenever I want. Please put a date. If the buyer is negotiating or has entered into an agreement to sell, the contract ends upon settlement. That is, let me read that again. If the buyer is negotiating or has entered into an agreement to sell, this contract ends upon settlement. I remember years ago, an agent said to me, he had a buyer agency contract that ended like 6 months later. They went to settlement on the property. The buyer found another property 2 months later, and the agent called the buyer and said, you owe me a commission. I'll never forget that. And I said, well, why would that buyer owe you commission? He said, because the contract didn't expire, Trent, it doesn't expire for 6 months. I said, well, you think that you're entitled to anytime this person purchases a property for the next 6 months, you get a commission based on that? And he said, yes. That's why you should know what's in these contracts. And I pointed him to the contract that he signed with his client. If buyer is negotiating or has entered into an agreement to sell, this contract ends upon settlement. This contract, even though you have a buyer agency contract that ends 6 months from today, you went to settlement today, this buyer agency contract has ended. It is over. It's done. That buyer can go out tomorrow and buy as many properties as he or she wants, and you are not entitled to a commission or a fee. Any questions, comments? Paragraph 2 says,
I got a question.
Yes.
Yeah, let's say that the client doesn't say exactly the truth, and he or she's already signed up with somebody else, and then the whole sale goes through, and then we find out on the way that this person actually has somebody signed already, a contract with another broker. How did we are involved in this situation at the point that we find out that this is the situation?
Well, it wouldn't be if they lie. You're saying they didn't tell the truth when you ask them if they're working with another broker, correct?
Right.
Then what would happen? That's not that you wouldn't know they're not telling the truth. But what will happen? The buyer may have to pay 2 commissions, because if he or she has a buyer agency contract with you, he owes you or your office a commission. But if that buyer also has an exclusive right to sell, exclusive buyer agency with another brokerage, then he or she also owes that brokerage, that other company, a commission. So by lying, you may have gotten yourself into a little bit of trouble, because a buyer agency contract says, an exclusive that is, says that no matter who finds this property, if I buy a property before the end of this term, on or before the end of this term, I owe you a commission, which means you may just owe 2 commissions to 2 different offices. And I don't think any buyer wants to pay 2 commissions to 2 different offices. So
that was clear when you, right, that was clear when you explained it, but the thing is that even if you explain to him at the time and he's still doing it, let's say we go to a settlement, and at this point we find out that that's the situation, that she already has signed up with somebody else. They're going to get back to you for something, or you just don't, nothing to do with it. Just go ahead and.
Well, what I do,
because the money's already paid to everybody.
Well, I'd say that's a decision for you or your broker. Sometimes I've gone after people, sometimes I haven't. It depends. It probably depends on the amount. It depends on the attitude of the client. I've not been in that situation maybe once or twice in my life, but it depends on the situation. I got the variables. If a person's just being sneaky and they bought a property and didn't pay your commission, and maybe if it was a $2,000 commission, do I go after them? Probably not. But if it was a $20,000 commission, I may go after them just for. I once went after someone just for the principle of the thing, because what they did. So I think that's a personal decision between you and your broker. I don't know if you're the broker, but between you and your broker, because I think it depends on a lot of variables as far as I'm concerned. All right. All right. Let's look at the broker's fee. Again, everything in real estate is negotiable. No association of realtors has set or recommended a broker's fee. They can't do that because that would be an antitrust violation. Brokers can set whatever fees they want for their office without any kind of feedback or any kind of consultation with another broker. If I, as a broker, contact another broker about fees, then I have committed that's price fixing. That's a clear antitrust violation. I can set whatever fees I want from office. I can say, hey, I want 30% commission on every sale. Every buyer has to pay a flat fee of $20,000. I can set whatever, and I can advertise those fees. I just cannot contact another company and we talk about fees, commissions, rates. That's when you have an antitrust violation, when you reach out to someone else. but you can set whatever fees you can. And I will keep, I think we all, well, I won't say we all, I see a lot of agents talk about commissions and things. I just think there's a problem when you start talking to other agents and other offices about commissions, even what you get. I've always stayed clear of that. I don't want to talk, I don't talk to anyone, no other brokers about how I structure my fees. But Trent, how do you pay you? What do you pay agent? I don't talk about, because I think that is an issue and I don't want issues. I don't talk about how I structure my fees, my management fee, any of that. That is something that is decided by me as a broker without any input from anyone else. And I will keep it that way. And you ought to keep it that way, so you stay within the confines of the law. All right. So no fees are set by anyone but your office. Go down to B1. If a seller in a purchase, if the seller is represented by a real estate agent, then put the fee. If a seller in a purchase transaction with a seller represented by a real estate broker, the fee is blank, whatever fee that is. Again, we can't talk about what fees are or what you should charge, whatever you negotiate. That's between you and your broker. So whatever that fee is, you put there. If it's 5%, 8%, 20%, whatever it is of the purchase price, and you would put some, maybe some offices want maybe a flat fee. You may say, I want either 7% or 20,000. So whatever that is. So if it's a fee, if it's percent of the purchase price or a flat fee, then you will put in that second blank, whichever is greater. And some offices charge broker service fees or some other type of fees. You will put that there. Maybe you charge a conveyancing fee, a broker fee, whatever that is. If that's 500, that's 800, that's 1,000, you will put that there. So remember, fees must be disclosed. You cannot charge by any client's fees unless they have been first disclosed to that client. You can't get the settlement and say, oh, by the way, there is a broker service fee we charge of $1,500. Well, the buyer could say or should say, I'm not paying it because it's never been disclosed to me. If your office charges fees, disclose those fees up front. And if you represent a buyer, then you can disclose it right there. All right. Now, the second part, B, if this seller is unrepresented, this is a for sale by owner. So with a seller who is not represented by a real estate agent or real estate broker, the fee is blank, or the purchase price or whatever. And again, if there is another fee. So the A is what you use that if the seller is represented by a licensee. B, if the seller is not represented by a licensee, what are you going to charge the buyer in this situation? What's the buyer's fee to you if the seller is unrepresented? Number two, broker's fee in event of a lease transaction. Now, even though that buyer may be looking for a house, I would still fill that out. Why? Because have you ever had a buyer who's looking for a house decided not to buy a house and decide to rent? Well, maybe they want to rent that house or they want to rent another house. If you're working with them, then why not put whatever the fee would be if there is a lease? It may, most people just put NA, you still could, but why not? If your fee is 1 month's rent or 2 months rent, put it there. I've had buyers who they would set out to buy a house, but they end up renting the house. So why not just put it in the contract so it's there in the event that that situation ever occurred? Number three, it is a broker's policy to accept commission offered by the listing broker. If the amount received from the listing broker is less than the amount in paragraph 2B, then the buyer will pay the broker the difference. You need to let buyers know if, for instance, on paragraph, if you said that we want a commission of at least 10,000, the seller's offering 8, then the buyer will owe your office 2,000. Some brokers will just say, we're just going to accept whatever the listing agent or the seller is offering us as commission. And we, even though we may put here 3-4%, but they only offer 3, so we'll just accept 3. But again, make sure you know what your office policy is, because your office may have a minimum commission. So, but you have to let a buyer know that that buyer may, if that's the case, that buyer may be responsible for paying you a commission or part of a commission. Again, you need to be clear. You don't want to get the settlement and say a buyer, oh, by the way, we only earned $20,000 from the seller, but our minimum is 30, so you owe $10,000. You don't want to get, you want to be clear if that is the case, if you're expecting the buyer to make up the difference from what the seller is offering, all right, and what you expected. I hope that's clear. All right, paragraph 4, it says blank of the broker's fee is earned and due at the signing of this contract. That would be upfront fee. Whatever, if your office, some offices now charge an upfront fee. Let's say your office charges $1,000 upfront fee. Well, you will put that there. If you don't charge an upfront fee, fine. Keep in mind, an upfront fee is part of the commission. It's not in addition to the commission or the fees, it's part of it. Take a look at the next paragraph where it says the balance of the broker's fee. The balance, because if you charge an upfront fee of $1,000 and you expected $10,000 from that buyer, then that buyer owes you $9,000. So the balance, that is if you charge an upfront fee. If there's no upfront fee, obviously there's no balance, you owe the full balance. The balance of the broker's fee is earned if the buyer enters into an agreement of sale during the term of this contract, whether brought about by the broker, one of the broker's licensees, or by any person, including the buyer. This is what makes this an exclusive buyer agency contract, because it says that the buyer fee is earned if the buyer enters into an agreement of sale during the term of this contract, whether brought about by you, the broker, by one of your licensees, or by yourself, or anybody, including the buyer. So that's what makes this a buyer agency an exclusive buyer agency contract, as opposed to a non-exclusive. That paragraph says, hey, buyer, no matter who, if you buy a property, if this contract expires March 31st and you buy a property by March 31st, then I have earned the commission, period. Even if you, no matter who sold it to you. All right. Oh, all the way, go back to paragraph 5 where it says other. If there are any other fees, if you had some other fees, make sure you would put that. I mean, so if you had a fee, so that number, paragraph 4 is if you charge an upfront fee. Paragraph 5, if you charge an addition, some other fee, maybe you charge a fee for copies, I don't know. Then again, this is part of the broker's fee, not in addition to it. All right. Any questions? Any comments? If not, go on to D, paragraph D. 2D says if the buyer enters into an agreement of sale for property after the ending date of this contract, buyer will pay broker's fee if any 3 of these happens. The agreement of sale is a result of the broker's actions during the term of this contract. So if this contract ended in the February and you showed that buyer the property that he or she ultimately purchased, then you would have earned the commission. So the agreement of sale is a result of the buyer broker's actions during the term of this contract. Also, or the property was seen during the term of this contract. They buy a property that you showed them again that, I mean, you showed the property during the term of the contract, they purchased it. After this contract expires, you would be entitled to your commission or your fee. Or if the buyer is not under an exclusive buyer agency with another broker. So if that buyer is under contract, an exclusive buyer agency with another office, then you would not be entitled. Okay. Dual agency, we mentioned earlier, dual agent. See, broker agrees that broker and the broker's licensee stated above may also represent the seller of the property that the buyer may buy. A broker is a dual agent when there are 2 ways you can be a dual agent. When a broker represents both buyer and seller in the same transaction, number 1. Number 2, a salesperson or licensee is a dual agent when a licensee or salesperson represents buyer and the seller in the same transaction. So if the company represents both buyer and seller, Remax First represents buyer and the seller, you're a dual agent. If you, the agent, represent the buyer and the seller in the same transaction, you're a dual agent. All right. And if your office does not practice dual agency, and I think there are a few around that don't practice dual agency, then you would use the single agency form. Take a look at the last paragraph. Look at paragraph 16 on the special clauses. If your office does not practice dual agency, then you see it says single agency addendum. Then you would use that form, which says to the buyer, we don't practice dual agency, single agency. We only represent one party at a time. Dual agency, obviously you represent both. Two, single agency, you represent one. So if you don't practice dual agency, then you would just have them sign the single agency form. Designated agency, we kind of talked about what that is. If your office is not, practice designated agency, just check the box that says designated agency is not applicable. Only you will know that. I would not know whether it is. You would know that in the office. If you don't know, ask your broker, do we practice designated agency or not? All right, because you really want to be able to tell that to your buyer. And number 5, broker services the others. Brokers may not take action that is inconsistent with the buyer's interest. That is clear. You can't, if you have a fiduciary, you have a fiduciary responsibility to do what's always been in the best interest of your client. Loyalty. Remember, that's one of those fiduciary responsibilities that you have once you enter into an agency agreement. Loyalty means that you put your interest, or everybody's interest is secondary to your seller, in this case, your buyer's interest. No one's interest trumps your buyer or your client's interest, including your own. That means you shouldn't show properties based on commission. We know agents do that. They'll send their buyers only commissions with the highest properties, the highest commissions. That means you put in your interest. Here's your buyer's interest. You put in your interest above the interest of your client. When you have a fiduciary relationship with someone, you put your interest. No one's interest is higher than this person's interest. So if you're showing properties based on how much money you will get out of it, you put your client's interest under yours, that's a clear violation of your fiduciary responsibility or duties that you have to that buyer. All right. 2 says the broker or the licensee may show the same property. Here's something that a lot of buyers don't seem to understand. This has come up many times in my career. Brokers may show the same property to other buyers and may represent those buyers in attempts to purchase the same property that the buyer wishes to purchase. Broker does not breach a duty to buyer by showing a property buyer is interested in to other prospective buyers. Believe it or not, lots of buyers think that is a conflict of interest. They think that if you show them this property in West Oak Lane and they're interested in purchasing it, that you should not show someone else that same property and write up a contract for someone else. And so make sure you let buyers know that, yes, if it's a market like this, we're in a hot seller's market still, there's not a lot of inventory. If I work in a certain area, then there's a good chance that I may show that same property to 3 or 4 buyers. And I may write up, I think one year I wrote up a property, represented 5 different buyers. I wrote 5 contracts on the same property for 5 different people. Obviously, I'm not sharing what each one I'm writing. I submitted what they wanted me to submit, but one of them ended up getting it. But I tell my buyers, unfortunately, you're not the only buyer in any market. There are other buyers. That's why I love it when I go in a house, and they don't do that now, where you can see that you used to see all the agents' business cards. I would point that out to my buyers and say, hey, you see, you're not the only person looking at this house. Look at all these business cards. Or as we approach, we see people coming out. I say, hey, you see, there are other buyers, prospective buyers. So if you're interested in this property, you may not have 4 days or 3 days, or even 2 days to make a decision. You may have to make a decision right away. I don't pressure anyone, but I think you'd want buyers to know this is the market we're in. You right now, you see a property, you probably need to go write it up ASAP. and give them the strongest offer you can if you hope you have a chance of getting it. And C says it is a conflict of interest when the broker or the licensee has a financial or a personal interest in the property and or cannot put the buyer's interest before any other. Obviously, if you have an interest, if you have any conflict, for instance, you are trying to purchase a property that you have listed, or you competed, well, in this case, you competed with the buyer, you show the buyer a property you think is a great property, so you put in an offer. Well, I think that's a conflict. I think that's an issue because you're representing the buyer. You know what the buyer's offer is. There's a conflict. You should say, hey, buyer, I'm going to buy that property, which I think will be a mistake. I'm going to buy that property, so maybe you should find another agent to write it up because I don't want to compete with you. Obviously, I think that's a bad idea. I would never do that. I would recommend it. If you, the agent, should not be buying that. I'm not gonna say I wouldn't do that. All right, maybe someone else would. All right, any questions, any comments? No questions, no comments, nothing? You all go. All right, can someone say something again? Make sure you all can hear me. Maybe you all can't even hear me all this time.
I have a
Here.
question.
Thank you.
Go
Here
on.
now.
What was that?
Trent, I can't remember the whole bar. Could you please run through that quickly?
Say that again.
Can you run through old car, please?
An old car. Old car are the 6 fiduciary responsibilities you owe to a client. You owe an old car to a client, not a customer. You owe a customer fair and honest dealings. An old car, you owe them obedience. O is obedience. You must obey the instructions of your client. You owe them loyalty. You must put your interests below the interests of your client. You owe them disclosure. Anything you know about that property, you need to disclose to that buyer. You owe them confidentiality. Anything they tell you is confidential. You cannot repeat anything that buyer has said to you. And the confidentiality lasts forever. And for accounting, you must account for any personal property or monies that they give you. Buyer's going to give you earnest money deposit check. That means you have to make sure it's stored somewhere where it doesn't get lost. So you must account for any personal property. If they give you, like a seller gives you keys, if they give you garage door openers, you have to make sure you take care of those things that have been entrusted to you. And R is a reasonable degree of care. You, as a real estate professional, should use care. You as an expert they're hiring you because of your specialized knowledge in real estate. So you ought to have some specialized knowledge.
Thank you.
All right. Anybody else? Any other questions, comments? All right, go back to where are we? The entire contract, paragraph 6. This contract is the entire agreement between the broker and its buyer. Any verbal or written agreements that were made before are not a part of this contract. All changes to this contract must be in writing and signed by the broker and the buyer. Make sure anytime you make a change to any contract, you must do it in writing. Remember, we don't do verbal contracts in this state, probably no state. You don't do verbal contracts. Everything must be in writing. What form do you use if you want to make any changes to this form? You should have in your papers the change to buyer agency contract form. Take a look at that. The change, and I thought I had one, but maybe not. The change, yes, I do. The change to buyer agency contract. If you want to make any changes to this buyer agency contract, use the change to buyer agency contract. All right, use that. So let's say you want to extend it by another month or 2. Use the change to buyer agency contract. So that's you. I've never been a fan of people crossing things out and writing things and initial and stuff. There have been times I can't read the date that they put. I can't read something they wrote. It's better to just put any changes on this form It's easier for everyone to read. No one can then say, wait a minute, what date is that? Or I thought it said 1,000, but you look like you said, just use the change to buyer agency form when you want to make any changes. All right. Paragraph 7, the transfer of this contract says the broker agrees that, the buyer agrees that the broker may transfer this contract to another broker when the broker stops doing business. That broker goes out of business, he or she transfers it to another company. That buyer is still bound by this contract. Brokers, or if the broker forms a new real estate business, you have a real estate business, you're going to form a different one. This contract is just going along with that same broker, or if the broker joins his business with another. So we merge, my company merges with another. Your contract with me is still good, even though it may be a different name. The company, we may have a different name for the company, but confidentiality, we just talked about, that's one of the fiduciary responsibilities or obligations you have to a client. Confidentiality means that whatever your client says to you is confidential. It is private. You don't repeat conversations you have with clients to anyone outside of your office. You cannot, even if 5 years later, you can't say, you know what, that was my client. I was selling her house, but it had a lot of structural issues and I couldn't sell it. Well, you shouldn't repeat that to anyone ever, because if you repeat that and maybe that person was thinking about buying it and then they say, oh, well, I'm not buying this property now because the agent told me there were structural issues years ago. Just whatever you learn from whatever your client tells you by the buyer, seller, it is confidential. Confidentiality lasts forever. All right. Confidentiality, back to paragraph 8, unless permitted by buyer or required by law, broker will not knowingly reveal or use any confidential information of the buyer. Buyer understands that sellers or sellers representatives might not treat, this is also important, might not treat the existence, terms, or conditions of any offer as confidential unless there is a confidentiality agreement between the buyer and the seller. A lot of times agents believe that when they submit an offer to a seller, the seller is bound by confidentiality. That is not the case. Be clear. If you submit an offer to a seller, the seller can say whatever they want about your offer to whomever they want. There is no confidentiality that the seller owes a buyer. The confidential, I owe my client confidentiality. That seller's agent will owe that his or her client confidentiality. But if a seller gets your offer and says it's okay to tell every buyer what John Smith presented, you can't say anything. What's the name of the person? John Smith presented an offer of $400,000 with seller assist and bankrupt. You could disclose that, and there is nothing that you can do. So buyers need to understand that once they submit an offer, unless there's some type of confidentiality agreement that says they can't reveal what's in that contract, then they're not bound by it. Can you add a line about the seller not sharing personal information? Yeah, but does that mean they do it? I don't know. Now, let me just say this. Years ago, I represented an athlete who did not want people to know that he was buying property. And he said, so I said, we'll sign a contract. Before I present the offer, I told the agent, your client needs to sign a confidentiality agreement that says that neither you nor the agent will disclose that this person is looking to buy this property because he wants to remain anonymous. He didn't want anybody to know. And that's what we did. So yeah, you can sign a confidentiality agreement. You can ask the seller, but let's be realistic. Most sellers are not going to repeat it, but just understand they could repeat it. But most agents believe that, are under this false impression that once you submit an offer to a seller's agent, that seller's agent must keep everything in this offer confidential. It is not the case. All right. It is just not the case. I can say whatever I want. If I got 5 offers and you call and say you have an offer, I said, yes, I have an offer from this person, and tell them the exact amounts. I could do that. All right. Any other questions or comments? Number 9, expertise of real estate agents. Remember, you are not an expert, and you're supposed to be an expert in real estate. You are not an expert in law or science or accounting. You refer people to the experts if there are questions. So experts, if a buyer wants information, 9A, regarding specific conditions or components of a property which are outside the broker's or the licensee's area of expertise, buyer is encouraged to seek advice of an appropriate professional. Don't stay in your lane. If someone's asking what are the tax advantages or disadvantages if I do this as opposed to that, send them to an accountant or financial advisor. Don't say, well, I think if you do the LLC, if you do this, stay in your lane. Well, this used to be a gas station 30 years ago. You think they're in the underground tanks that may be leaking? No, that was 30 years ago. I'm sure that this is fine. Stay in your lane. If you want, I'll send you to, or you go find an environmental engineer who can test the soil. But stay in your lane. Don't assume that, for instance, that because this this seller is operating a daycare out of his or her property, that you can operate a daycare out of that property. Maybe they're just doing it, and don't say, well, if they're doing it, even though zoning, it doesn't allow it, but I'm assuming it's okay. Don't assume. They know what they say when you assume. Stay in your lane. Send them to the appropriate professionals. That's where agents mess up. That's where agents get in trouble. Start thinking that they're an expert on a lot of topics. It is okay. People respect you when you say, I don't know, contact X, contact Y. Don't be an expert on a topic where you are not an expert. All right. So a buyer wants information. Send them to, they're encouraged to seek the advice of the appropriate professional. And B, if the buyer wants financial, legal, or any other advice, buyer is encouraged to seek the services of an accountant, a lawyer, or other professionals. Don't ever discourage a buyer from talking to a lawyer or an accountant or anybody. If that buyer has questions, encourage them to speak to a professional. Don't say, oh, you don't need a lawyer to look at this. And I've heard that many times. Oh, listen, a lawyer's just gonna charge you a lot of money. And they don't know. You don't discourage people. Encourage them if they want, because it always comes back on you. All right, because now it looks like you trying to just get this deal done so fast, you don't care if there's an issue that comes back later. You just want to get this deal done. No amount of money, no amount of commission is worth you losing your license and having a reputation where nobody wants to work with you. Deposit monies, paragraph 10. Buyer will keep all deposit monies that the broker or the licensee receives in an escrow account. We already know that, a trust or an escrow account, as required by the Real Estate License and Registration Act, until the sale is completed or an agreement of sale is terminated, or the terms of a prior written agreement between the buyer and the seller have been met. Buyer and seller may name let's take that. Buyer, first of all, make sure if you, I think I put in, look at the deposit money notice. I know you're all familiar with that. If you are collecting money from a client and that money will be turned over to someone else, by law, you have to give the buyer a notice. And here is the notice that we use. It is called a deposit money notice. Anytime a client has given you a check and that check is going somewhere else, they must be made aware. So take a look at deposit money notice. Paragraph 1 says the listed broker is a Pennsylvania licensed real estate broker is required to hold your sales deposit in escrow. This is, you represent the buyer. So you're saying we're going to turn your money over to a licensed broker, real estate broker in Pennsylvania. Number 2 says a selling broker, that's you're the selling broker, is accepting your deposit on behalf of and for transfer to the listing broker. I'm saying you're giving me, I'm the selling broker, you're giving me a check, but I'm going to turn your check over to another licensed real estate broker. And number 3 says if the deposit is in the form of a check, that check must be made payable to the listing broker. That's why we make the checks payable to the seller's agent or the seller's brokerage. So this just lays out to the buyer that you are giving me the money, but I'm giving that money to the agent for, or the broker for the seller, who must hold that money in escrow. Is that clear? Any questions? And the one thing that I think that agents should always do is make it clear to a buyer that, and seller, if there is an issue with who is entitled to this money, if there's a problem, no one can distribute that money unless something happens. The broker for the seller, the broker for the buyer cannot determine who or decide who's right, who's wrong. And let's take a look at that. It says buyer and seller may name, and let me cover that first. Buyer and seller may name a non-licensee as an escrow holder. In which case that escrow holder will be bound by the terms of the escrow agreement, not by the Real Estate License Registration Act. Here's why I don't like monies being held by a title company or a lawyer. I'm beginning to see more and more. I think this week or last 2 weeks, we've had 4 companies say, we don't hold escrow anymore. Either can your title company hold it, or I said, well, we'll hold it. I'm seeing that more and more because people don't want to have to deal with escrows. In Florida, the first thing when I opened my escrow account, every broker I met in Florida, they said, close that escrow account down, Trent. And I said, why? They said, in Florida, no one holds. Brokers don't want to hold money. Let the title company. So it's kind of customary in Florida for the title company to hold escrow. Brokers don't hold escrow in Florida. So I don't know if that's something they're trying to move to here, but keep in mind that if the title company or the attorney is holding escrow, they're bound by an escrow agreement, not by the rules and regulations of the Pennsylvania Real Estate Commission or the Real Estate License and the Registration Act. So keep that in mind. You want to make sure you know what's in that escrow agreement, because that escrow agreement may say, held by the title company, that if this issue is not resolved within 60 days, we turn the money over to the buyer. You may not want that if you're the seller and the buyer clearly breached the contract. So I think it's best, in my opinion, to have a broker hold it, because a broker is bound by the licensing laws and the rules and regulations of the Pennsylvania Real Estate Commission. So the broker can't just say, I'm giving the money to the broker, to the buyer, or I'm giving the money to the seller. No, no, no. Who gets to determine who gets the money? Let's keep on reading. It says, regardless, look at B, regardless of their parent entitlement to deposit monies, Pennsylvania law does not allow a broker who's holding deposit monies to determine who is entitled to those deposit monies when settlement does not occur. This to me is key. I have been around long enough to see so many buyers. I'm talking not necessarily my clients, but where they say, hey, sellers will say, the buyer breached the contract, give me the money. No, I can't. What do you mean they can't? I've had buyers come in and say, okay, the seller decided not to sell, give me my check, and say, well, we have to get a release. Well, I want my money, or I'm gonna sue. That's something different. So let's look at this. So if this agreement of sale, Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to those deposit monies when settlement does not occur. And it says, broker can release those monies only. There's only one of 4 scenarios. 1, if an agreement of sale is terminated prior to the settlement and there is no dispute. And how do we know there's no dispute? Because a buyer and a seller sign a release of an agreement of sale, releasing the money back to the buyer. That's clearly no dispute, because the buyer signed off on an agreement of sale release that says you can release the money back to the buyer. Clearly, now the broker can release that money back to the buyer. Number 2, if the broker receives a written agreement that is signed by the buyer and the seller directing the broker how to distribute some or all of the deposit monies. All right. So here, number 2, there was a dispute, but the buyer and the seller decided, okay, this is how we're gonna resolve it. It's a $10,000 commission. I'll take 6, you take 4. I'm okay with that. We agree. We give that release to the broker. The broker has a release signed by both buyer and seller. Broker writes a check, 6,000 to one party, 4,000 to the other. Number 3, according to the terms of a final. Final is a key here. Keyword there. Final order of court. Not so if there is a court order, but then that party who was awarded the money, that was the loss, decided I'm going to appeal, you still can't release it because that's not the final court order. That's after all appeals. So if now there are no more appeals and the court says that the buyer is entitled to the deposit money, now I have a final court order. I can write a check to the buyer. And the last one, number 4, according to the terms of a prior written agreement between the buyer and the seller that directs the broker how to distribute the deposit monies if there is a dispute between the parties that is unresolved. Now, what you put, if you don't have an agreement, I know you don't have an agreement sale in front of you, see paragraph 26C of the agreement sale. That is where that prior written agreement is located. In the agreement sale, paragraph 26C, I will read it to you. Paragraph 26C in the agreement sale, that is what we call a prior written agreement. Let me read it. So let me first say, buyer and seller agrees that that according to the terms of a prior written agreement between the buyer and the seller, that directs the broker how to distribute those monies if there is a dispute. There is a dispute between the buyer and the seller, but it's unresolved. Now take a look at, let me read paragraph 26C in the agreement sale. Buyer and the seller agree that if there is a dispute over the entitlement to deposit monies that is unresolved, and here it says 180 days, please don't leave 180 days, put 15 days, 30 days, don't leave 6 months, okay? Just let's read it as 30 days. Buyer and seller agree that if there is a dispute over the entitlement to deposit monies that is unresolved 30 days after the settlement or following termination of the agreement, whichever is earlier, then the broker holding the deposit monies will, within 30 days of receipt of the buyer's written request, distribute the deposit monies to the buyer unless the broker is in receipt of verifiable written notice that the dispute is the subject of litigation or mediation. In other words, if there is a dispute over who's entitled to the deposit money and is unresolved, if you have 30 days here, and within 30 days, then that buyer can send a letter to the broker requesting his or her deposit money back. If that broker has not received proof that the seller has filed a lawsuit, litigation, or has requested mediation, then the broker must give that money back to the buyer. Must. The buyer sends a letter, says this dispute has not been resolved within 30 days. You don't have, the seller has not initiated litigation or mediation. Therefore, broker, you must return my full deposit money to me. Last paragraph there says, the last sentence in that paragraph says, buyer and the seller agreed that the distribution of deposit monies based upon the passage of time does not legally determine entitlement to deposit monies, and that the parties maintain their legal rights to pursue litigation even after a distribution is made. So it says here that even if that distribution is made, that seller can come back and still sue. Is that likely to happen if it's not a lot? Probably not, but maybe if it's $50,000, you may, but if it's a couple of $1,000s, it's not even cost effective for that seller to sue. Any questions about this? No? Again, let me know you're listening. Maybe you all can't hear me.
Listening.
Listening.
So 2 people listening out of 24. Well, that's good. I guess-
Listening.
I guess
Oh,
2 out of 3
We hear
ain't
you,
bad.
Trent. We hear you.
I think Meatloaf said 2 out of 3 ain't bad. All right. I should say 2 out of 24 man in honor of Meatloaf, who just died a couple of months ago. All right, let's go on. Civil Rights Act. No, I'm sorry. C. Here's something that you want to know is here, because if a buyer or seller ever say to you, I'm going to sue you if you don't give me that money, and I've heard that, as you know, when there are disputes, buyers, sellers want their money back, and you have to let them know that I'm only the escrow holder, that I'm a holder of this escrow. I can't determine unless one of those 4 things are present. So C protects brokers and licensees like yourselves. Buyer agrees that the buyer agrees that the buyer names a broker or the broker's licensees or salespeople or associate brokers in litigation regarding deposit monies. The attorney's fees and costs of the broker and licensees will be paid by the buyer. So you simply remind them that if you sue me, I'm going to get the best law firm in the city because you have to pay it. You have to pay the fee. So they can't sue over, because the broker is, again, that's why I think a broker should hold escrow money, not an attorney, not a title company, because a broker has clear instructions as to when he or she can distribute that money. An attorney, title company, they have their own escrow agreement, and they may get to determine who's right or who's wrong. I don't want that. So I think it's best to have the escrow account, the escrow money in the hands of a licensed real estate broker. But you know, I'm not saying that a title company can't hold it, a lawyer can't hold it, but you need to know what is in their escrow agreements. All right. Civil Rights Act, paragraph 11. Obviously, you cannot discriminate against people based on their race, the color, religion, religious creed, sex, disability, familial status. Their age in Pennsylvania is 40. Age is not a protected class on the federal level, only on the state level, but it's 40. The national origin, the use of a handling or training of support animals, or the fact of relationship or association to an individual known to have a disability. For reasons for refusing to sell, show, or rent properties, loan money, or set deposit amounts, or as reasons for any decision relating to the sale or rental of property. If sellers tell you, buyers tell you to discriminate based on people in the protected classes, I would say even not in a protected class, you need to educate the buyer or the seller first. And if they insist, you should walk away. I've had buyers, sellers, landlords say, I've had landlords say to me, I don't want you to put children on the second floor. Well, that's a clear violation of Fair Housing Act. There's a clear violation of the Pennsylvania Human Relations Act. There's a clear violation of the what's in Philadelphia. I forgot the law, the code in Philadelphia. You would lose your license and possibly spend time in prison with the landlord. Do not accept listings or do not work with people who are telling you to discriminate based on anything. Even if it's not a protected class, if they say, I don't want you to put smokers in my, I don't want you to rent to anyone who smokes, even if they can't smoke inside. If they smoke, it seems to me a little silly. I would probably say, if you give me anytime you tell me, I don't want you to sell or rent to anyone, whether they're a member of a protected class or not, I'm not doing it. I choose not to take that list because I think it's silly. I'm not discriminating against anybody, and I'm not going to refuse anyone based on any of your idiosyncrasies. But be clear, if a person is a member of a protected class, remember on the city level, there are even more protected classes. Just so you know, under sex falls sexual orientation and sexual identity. That's only happened as a result of a Supreme Court decision. I think that was 21. So when the protected class of sex, so if someone discriminates against someone based on their sexual identity or sexual orientation, then they have violated they have violated the Fair Housing Act under the protected class of sex. Same with sexual harassment falls under sex. So if you are looking to rent an apartment and the landlord says, I only rent to you if you go out with me, then that is a violation of the Federal Fair Housing Act, so also the state and the city. And it's a violation of the fair under the protected class of sex. So under sex falls sexual orientation, sexual identity, and sexual harassment. And remember, if you think of race, that's any race. If you're a human, you fall into a race. So you can't discriminate against anybody based on race, color. You can't discriminate against anyone based on the color of their skin, whether they're dark, light, whatever the shade. You cannot discriminate based on color. You can't discriminate based on whatever religious, whether any religion or no religion. I always tell people, you can't say, if I only want to rent to someone or sell to someone who at least believes in something. All right, that is a violation of fair housing, because you say they can believe in nothing. You're protected if you believe in nothing. You're protected religious creed. You're protected because you have a certain diet because of your religion. You wear certain clothing because of religion. You can't say, oh, I don't want anybody who has a yarmulke on their head. But if that's a part of my religious beliefs and I wear this as a result of that, then that I'm protected. All right. Disability would be mental or physical. All right. A person who has a mental or physical, or if you perceive someone to have a disability when in fact they don't. Let's say, for example, you say, hey, I think that person has AIDS and I'm not going to rent to him because I think he has AIDS. Well, if that person doesn't have AIDS and you did not rent to him or her because because you perceive them to have AIDS, then you still violate fair housing, because you discriminated because of something you thought of, some perception. Well, it may have turned out to be some wrong, but you can't. So you can't discriminate against someone based on a mental, physical disability, or if you perceive them to have a mental or physical disability when in fact they don't. All right. Obviously, familiar status. Children under 18 are protected, and pregnant women. If you say I'm not going to rent to her because she's pregnant, you violate federal housing. You violate federal, state, and city law. Age 40. And on the national level, age is not a protected class. In Pennsylvania, 40 is protected. So if you say, I'm not going to rent to anyone over 40, then you have violated the Pennsylvania Human Relations Act, not the Federal Fair Housing Act, because age is not a protected class on the federal level. Age is a protected class on the state level, the city level. All right. Also, if you deny someone the right to use let's say a CNI dog or an emotional support animal because they have a disability. If you say no, even though you have a letter from a mental health professional says that you need this poodle as support, emotional support, but this is a no pets building, then I'm not going to allow you to have that pet. Then obviously that's a violation of law. Or if you say, if you have this dog, then you must pay a pet deposit or a higher security deposit. You cannot do that because let's go, for instance, like a CNI dog. A CNI dog, remember, is not an animal, it's not a pet, is an extension of the person. Always think of an animal, a CNI dog, as if they say no pets, it doesn't matter, because it's not a pet. This is an extension of this person. This is a person's eyes, or this person's arms, or this person's legs, this person, or this animal, or may alert this person when they're having, or calm this person when they have an anxiety attack. This person may remind them to take medication. This person may, pull the wheelchair or whatever. But this is not a CNI dogs are not pets. And so you can't refuse them. Otherwise, you in some trouble. Any questions? Any comments?
Hey, Trent, can I jump in for a quick second?
Yes.
So NAR has a really great simulation on their website. I just dropped the link in there, and it's called Fair Haven. It puts you through various situations that relate to fair housing. It's very interactive. It's very well done. It won't take up a boatload of your time. But next month, April, is Fair Housing Month. Exactly. And this is a really, really great refresher about fair housing issues. It's highly interactive, And it's a really great tool. So I suggest everybody make a visit to Fairhaven to either one, reaffirm that, hey, you're doing the right thing, or perhaps, oh, I never thought about that.
Exactly.
Because sometimes you can inadvertently, you get the best intentions in the entire world, and you went into an area that crosses the line, and you next thing you know, you're like, how did I get here? So please encourage everybody to check out Fairhaven. It's really great. You could start it, stop it, go back to it. So you don't have to do it all in one sitting. It's a really great tool. Thanks, Trent.
And thank you, Matt. I think it's a great idea, and right. And I thank you, Matt, for that, because fair housing, April is fair housing, and I agree with Matt 100%. A lot of times we could do things not realizing we're doing them, and we're violating fair housing. And I'll give an example. It's easy to say, and I've heard sellers say, "Oh, there is a elderly man who lives on the first floor. Would you not put like children upstairs because they may be noisy, and and so I'm trying to protect this man." Well, that sounds great, but if you say, okay, I won't put children on the second floor, that's a violation of fair housing. Whether your intentions are good, honorable or not, is a violation. So you need to understand there are some exceptions to some of these, but that is not an exception. That is not an exception. You can't say I'm not going to put children above a man who has some sickness, because to protect the man, you cannot deny a person the right to be able to live where they want or where they can afford. That would be a violation of fair housing. So you definitely want to stay clear of that. And it's always good to brush up, because we can inadvertently do or say things that may cross the line, as Matt said. Let's look at paragraph 12, Megan's Law. Megan's Law, this disclosure is mandated by state law. It has to be in these documents, because buyers are encouraged, of course, to contact the municipal police department or the Pennsylvania State Police for information related to the presence of sex offenders near a particular property. If someone asks, are there sex offenders in this neighborhood? Don't you dare check for the buyers. You give them, that's why this website is here. Don't ever, under any circumstances, go on the website and say, nope, I don't see any sex offenders in this neighborhood. Then you missed that one who lived 2 doors away who attacked this person's child. Now you are in trouble. Never check a website for, same with crime. If they say, buyer asks you, is this a safe neighborhood? Don't say yes. Don't give them statistics. Send them to the police department. Send them to a website. Say, hey, I'll give you the number to the police district. I'll give you the phone number. You can go on their website, but don't say to someone this is safe, because if it's safe and you say it's safe and they buy the property because you said it's safe and they get mugged that night, they're coming back to sue you because you told them it's safe and now they claim it's not safe. Send people to the appropriate websites or organizations. Don't stay in your lane. Stay in your lane. All right. So look at that. Let's say so buyers are encouraged to contact the police department or state police relating to the presence of sex offenders near a particular property, or to check the information on the Pennsylvania State Police website. There is a website. You tell them, go to www.meganslaw.state.pa.us. That's where they can find out whether there are sexual predators or convicted sex offenders living near the property that you are thinking of renting or buying. But don't you ever, under any circumstances, check for a buyer or tenant. All right. Any questions, any comments? Buyers inspections. Unless the buyer, paragraph 13, unless the buyer and the seller agree otherwise, the real estate is sold in its present condition. Now, of course, it's not going to be, if you waived everything, if you waived all inspections, clearly you're buying a property as is. So unless they agree otherwise, obviously, if you check to do a home inspection, it's no longer in its present condition. It is a buyer's responsibility to determine whether the condition of property is satisfactory. How do you do that? By doing an inspection. Buyers advised to carry out an inspection at the buyer's expense by qualified professionals to determine the condition of the structure or its components. Buyers should discuss further down inspections and any special needs with their agent. B says that buyers advise that information regarding properties considered for purchase by the buyer has been provided by a seller or seller's broker. Such information, be clear to point this out to your buyer. Such information may include, but it's not limited to, the information the seller's blah, blah, blah. In other words, don't rely on any information the seller gives you. Verify it. Verify. Because the seller gave you a seller's disclosure that says no termites. That doesn't mean you say, you know what, seller said there are no termites, I'm not going to have a termite inspection done. No. A seller, and let me say the seller in that example, the seller may not know that property has termites. Seller's answering honestly, are there termites? No. No one's ever told me there were termites. I've never had it treated. I never had a problem. But there may be termites in there eating up a lot of the wood in the basement. I didn't know there were termites. So you need to make sure that buyers know that all the information coming from a seller or the seller's agent is information you need to verify. Oh, they said it's zoned this. Well, it's zoned for daycare, but I want to operate X. Well, I want to make sure, verify, don't just, and the seller says, oh, it's fine if you operate X. Verify, don't just accept the word sellers. Verify whatever information you want that's important, make sure you verify. And don't ever use a seller's property disclosure as in lieu of a home inspection. And I've seen buyers want to do that. They said, well, I'm looking at the seller disclosure and there's no problems with the property. Well, there's no problems that the seller is aware of. Seller may not know that his or her roof is bad because the seller's never gone on the roof. The roof doesn't leak, but the roof has issues. The seller didn't know that the heater had all kinds of problems. Well, because it's worked so far, but maybe it has some issues and it won't work much longer. Just because they're not disclosing issues does not mean there aren't issues. So don't ever take a seller's disclosure in lieu of a home inspection. Seller's disclosure is something in addition to whatever you do. All right. So it says, unless otherwise noted, the broker has not verified. You tell them that I haven't verified any information that's out here. Unless otherwise noted, broker has not verified the accuracy of this information, and the broker is advised to investigate its accuracy. If the seller says that bedroom, the master bedroom is 10 by 10, and you base it on, you have furniture that you know will fit if it's 10 by 10, but if it's smaller, it won't fit. Verify. Don't just take the word of the seller. Seller may be wrong. All right. If that's important to you, then let's go back and measure that. All right. Or you go measure. I wouldn't measure. I'll take the buyer back and you measure because again, I don't want, I'll let you do that. All right. Paragraph 14, recordings on the property. Any person who intentionally intercepts oral communications by electronic or other means without the consent of all parties is guilty of a felony under Pennsylvania law. Remember, this is a two-party consent state. You cannot record anyone, listen in on their phone, listen in on their conversations without consent. So sellers now have these houses with all this technology and these devices, and they may be listening in on conversations. I believe I've been in at least one house where that happened. I was certain they were listening on our conversations because of the stuff the agent said right after I walked out the door. And my advice to you is to have conversations outside of a house. I do not hold conversations in a house because I don't know if people are listening. I think it's best to say, let's wait till we go outside and let's talk about things. All right. Don't have buyers. I've had buyers who want to videotape the house or take pictures. I don't allow that. Now, you can get permission from the seller, but if we walk in and they say, I'm going to take pictures for my mother, I said, no, I don't have permission for you to do that. this is someone's home. I don't want people taking pictures of my house. Maybe you're going to see some personal information that was left on the table. I don't want videotapes. I don't want that. And I generally don't ask sellers. I tell buyers, no, we're not videotaping. We're not taking pictures. We're gonna go into the property and look at it. All right. Now, if they really want pictures, maybe I'll ask the seller's agent for permission, but I typically don't want buyers taking pictures, definitely no videos in someone's house. It is not their house. All right. So buyers should not make recordings on the property that capture the oral statements of other persons without the full consent of all parties who are parties to the communication. Buyers should be aware that a seller's property may contain smart home technologies and devices which may record or allow for remote monitoring of the seller's property, including broadcasting or recording video and audio. Buyers should be aware that any discussions, including discussions of negotiation strategies held on the property, may not be confidential. Therefore, take them outside and have them when you walk out the door. Any questions, any comments?
Yes, Trent, if it's a vacant property.
What was that?
If it's a vacant listing, can they take pictures?
Should you, what about it? Can they take?
If the buyer wanted to take pictures or
Well, I would
video,
get permission. I would
Either
ask
way.
the seller's agent. I would never, no, I would not let them do it without me getting permission. Because still, even though it's vacant, some sellers don't want you to have pictures of the house. Maybe they think that now I have pictures of a window. Think about it. I see how your windows are made. Well, maybe I'm coming back, or I'm going to come back and break in. I think if that's what they want, then just get permission from the agent. I'd never just allow, I would not, and maybe someone else may be different. I would never allow a client to go into even a vacant property. And now if it's a shell, I think that's a little different. But a property that's vacant but it's not, that's livable, I would get permission. You may not. I mean, I'm sure a seller probably says, okay, a vacant property, don't live there. But if a person lives there, I'm always weary about taking pictures in a house where people live. And now I got a picture of your children in one of my, I don't like that. I don't allow that. I usually tell them, hey, what if you're selling a house and someone want to take pictures, what can come into it. A lot of things could show up in a picture. And they're like, oh, you're right. So that's never a problem. All right, the Real Estate Recovery Fund. Also, we're all aware of the Real Estate Recovery Fund. This disclosure, of course, is required by the Real Estate License and Registration Act, as well as the rules and regulations of the Pennsylvania Real Estate Commission. The Pennsylvania has a Real Estate Recovery Fund to repay any person who has received the final court ruling against a Pennsylvania real estate licensee or salesperson, associate broker because of fraud, misrepresentation, or deceit in a real estate transaction. The fund pays persons who have not been able to collect the judgment after trying all lawful ways to do so. I'm sure you all are familiar with the Real Estate Recovery Fund. If not, if you defraud a client at the time that at the time you defrauded this client, you had to be licensed. If you're not licensed, then you can't come to the Real Estate Recovery Fund. So if I'm deceiving you, but I don't have a real estate license, it's not available to that client. Only at the time that person was deceived or misrepresented, then can they go to the Real Estate Recovery Fund. But first, they must go to civil court, get a final judgment against that real estate licensee, who may not be licensed later, but at the time this behavior occurred, that person was licensed. You get a final judgment against that licensee. You try to collect on that. Let's say you get a judgment for $15,000. You try to collect against that real estate salesperson or broker or associate broker. You can't do it. So within 1 year, you have to come to the Real Estate Recovery Fund with that final judgment and say, hey, I have a final judgment against one of your licensees. At least he or she was licensed at the time this occurred. I don't know whether they're licensed now. If you have to show, first of all, it can't be your spouse or personal representative for the spouse. But I was defrauded by my salesperson. I went to court. I got a final judgment. I came to the Real Estate Recovery Fund within a year, and I can get a maximum of $20,000. So I have a $15,000 judgment. The Real Estate Recovery Fund will then pay that $15,000 judgment on behalf of that licensee. You can only get up to 20,000. One person get up to 20, and the real estate recovery fund can pay out to 100,000 per licensee. So 5 people can come and collect up to 20,000, with 20,000 the maximum for one individual. Once the real estate recovery fund pays out any monies, your license, the license of that salesperson, is automatically suspended until that licensee pays back all the money, including 10% interest each year. Any questions? Any comments? All right. And special clauses, paragraph 16, the following part of this buyer agency contract. We talked about the single agency addendum. If you don't practice dual agency, then use that single agency addendum. This is also a good place to put, oh, you know, let me just say, let's say no one asked me, sometimes buyers won't sign. They don't want to sign this. Has anybody had an experience where a buyer says, I don't want to sign a buyer agency contract? And what do? Well, what I suggest, if you have a buyer who doesn't want to sign a buyer agency contract, there are 3 different things I tell people. Sign a short-term contract. Make it for a week, make it for a day, make it for a month, make it short-term. So you say, buyer, all right, you don't want to sign one. How about for a weekend? I'm gonna work with you this weekend. So if any properties I show you this weekend, you end up buying, then I have to be your agent. So after Monday, you can go anywhere you want. So that makes buyers feel more comfortable that you say, hey, we're going out Saturday. We'll just have a buyer agency contract, exclusive buyer agency contract just for Saturday up until midnight. After midnight, this contract expires. But if you buy any of the properties I showed you, I'm the agent and I'm entitled to the commission, but you can go to anyone else. So you can make it a short-term contract. Number 2, you can provide a cancellation provision in the contract. And what made me think of this, I will put it under additional terms. You can say, all right, if you at any point you want buyer, you want to terminate this buyer agency contract, you have to give me 2 weeks notice, and then you can terminate it. And I could do the same thing, maybe for both of us. Either one of us can terminate within a certain time period. So that makes a buyer feel like, okay, so I'm not bound by it. I'm signing, let's say, a 3-month exclusive buyer agency contract. But if I don't like you, or if I want to use someone else, all I have to do is give you a 2-week notice. Okay, I'm okay with that. That means that I have a way out. I'm not stuck. I'm not bound to you for the next 6 months. Or I can use a non-exclusive buyer agency contract. Non-exclusive buyer agency contract means that I can represent you. You can go to as many agents as you want. But if I show you the property that you ultimately buy, then I'm entitled to the commission. So those are the 3 ways. Those are the 3 things that I would do one of those 3 if that buyer hesitates. Now this is a key. This is a key. Sometimes a lot of agents do not even have buyers sign buyer agency contracts. The Pennsylvania Real Estate License and Registration Act says that you can work with a buyer without them signing a buyer agency contract. But it also says that you cannot be paid a fee or commission, whatever, without one. So keep in mind that you can represent a buyer. I don't suggest it, but you can represent a buyer without a contract, but you are not legally entitled to collect a fee or commission without one. All right, you cannot collect a fee unless you have a buyer agency contract, because you remember the buyer agency contract, all the listing agents, all of them are employment contracts. That in this case, the buyer is hiring the agent to find him or her a particular property for a certain within a certain time period. If you don't have a contract, you can't be paid. You're simply a volunteer. All right, you're just a volunteer. And then the buyer has read, it says the buyer has read the consumer notice. The buyer has read the entire contract before closing. The buyer must sign his contract. And also remember that anytime a contract is signed, at the time the contract is signed, you must give a copy to that person. You can't wait the next day. You can't wait the next hour. That is a violation of, I think, Section 604 of the Real Estate License and Registration Act. At the time this document is signed, or any document is signed by a client or anyone, you must give them a copy of it at the time that they sign it, not later. So if you're going out, take 2 copies. Obviously, if you're in the office or someplace, you can make a copy, or they can take a picture on their phone, but make sure you have 2 copies if you're out in the streets or you're going to their house, because you would have violated the Real Estate License and Registration Act. If the buyer is obtaining mortgage financing, buyer shall promptly deliver to broker a copy of the loan estimate and the closing disclosure. Remember, the loan estimate is what is given to the buyer within 3 business days of making a loan application. And the closing disclosure is given to the seller at least 3 business days before closing. Those documents are not given to us. They must be given to the client. We're not the client. That's why we're asking them to give us these documents, because we need them. But the title company should not send you the closing disclosure. They should not send you the lender should not send you the loan estimate. They should send them to the borrower or the buyer, and then they should turn them over to us. All right. So you need to ask them, hey, as soon as you get that closing disclosure, as soon as you get that loan estimate, send them to me, because the lender will not, or the title company will not, and they shouldn't send them to the agent. All right. And it says the buyer is, return of this contract and any addendum and amendments, including return by electronic transmission, bearing the signatures of all parties, constitutes acceptance of the party by the party. So if I email this back to you, if I fax it back, that's fine. You have a contract. It does not have to be a wet signature. This contract may be executed in one or more counterparts. So if there are 4 buyers and you send it to 4 different people, that's a countersign. If you got all 4 contracts back, as long as they're all the same contracts, and you have one sign this one sign this one sign, you can put them all together in one contract to create, put them all together to create one legal binding contract. So the contract may be signed in one or more counterparts, each of which shall be deemed to be an original, and which counterparts together shall constitute one and the same agreement of the parties. Notice before signing, if the buyer has legal questions, buyer is advised to consult a Pennsylvania real estate attorney. Notice that Pennsylvania, not Delaware, not Florida, not New Jersey. Don't go to, hey, my brother is a lawyer in Ohio. Well, laws in Ohio are different from laws in Pennsylvania. So if you have questions, buyer, go to a Pennsylvania real estate license attorney, not a person who's licensed in another state. And obviously the buyer signs, the broker, you put the name of the company as it appears on the license, not just Remax first. And then you will sign, because you accept it on behalf of the broker. And once signed, of course, you are now, both the broker and the buyer are legally bound by the terms of the agreement. And you have to give a copy to this at the time that the buyer signs it. And one other thing, let me say, did I have the buyer financial information? I think that's in your package. Let me just say one thing that I think a lot of agents kind of question this. Look at the assets and the liabilities on the buyer's financial information, because sometimes buyers, and I've had a lot of agents ask me, if my buyer has $200,000 in the bank, but my buyer only needs $50,000 to close, do I have to show $200,000? The answer is no. You only have to show enough to buy the property. You don't have to show that or state that your buyer has $2 million in the bank when he or she only needs $20,000 to close. I wouldn't show 20, I may show 30, I may show 40. You want to show, because that could be an issue too. If you show an exact amount and the seller says, wait a minute, they have closing costs of 20, they only have 20 in the bank. Well, what if something happens? There's no cushion there. So you want to make sure you show enough, but you don't have to show on the assets. It says the buyer must show at a minimum. I'm saying, I wrote this. The buyer must show at a minimum that they have sufficient assets to cover the expected closing costs. So your buyer does not have to put that he or she has hundreds of thousands of dollars, because that could hurt the buyer too, because if a seller sees this and says, wait, the buyer has 150,000 in bank and they want seller assist. They don't need seller assist. So you have to discuss that with your buyer. So, you know, whether you put it all, how much, that's a discussion between you and your buyer. Liabilities now are different. Buyers should be thorough in disclosing liabilities. You can't leave out that you have 3 car notes, that you have 4 mortgages. You have student loans. You cannot liabilities, because a seller wants to know, wait a minute, if this buyer has all these liabilities, perhaps we're going to have an issue. Perhaps a lender, how's this person going to qualify for a loan with all that debt? So you have to be honest and you must disclose all liabilities, but a buyer does not have to disclose all their assets. And the real estate owned, you have to list all the properties you own. All right. You can't, hide the fact. Employment is the same thing as assets. You only have to disclose the jobs that shows that you have enough income to qualify for a mortgage loan if you get a mortgage loan. For instance, if I make $100,000 in this job and that's enough to qualify for me to buy this property, I don't have to show the other job where I'm getting $50,000. You only have to show, you don't have to disclose the enough income to prove that the buyer will qualify for the mortgage loan, the mortgage amount. All right. Additional income, you can use, additional information. It says you can use this space, include any information that may help the buyer look stronger and or explain any issues not easily understood from the form itself. So if there anything that you want that could help your buyer, you put it there. You say, hey, the buyer has 4 mortgages, but their buyer's parents actually pay them, and I can prove that. All right. And the key here, take a look at the bottom where it says under that line, it says buyer, make sure buyers are truthful when they complete this form. Buyer affirms that the information is true and correct. Buyer understands that the information may be used as a basis for the acceptance or rejection of an offer by the seller, because the seller is looking at this information and decided, hey, I'm going to take this buyer over the other buyer. So this information must be true and correct. Buyers acknowledge that failure to provide truthful and correct information may result in the forfeiture of any earnest money deposits made by the buyer and may subject the buyer to other financial loss or penalties. You need to make sure, tell the buyer to fill this out truthfully. The agreement of sale, put a note, I'm looking for it, paragraph 8F. I put 8F because if the buyer lies on this buyer's financial, the buyer could lose his or her earnest money deposit. And I'll show you, it is on paragraph, on the agreement of sale, on paragraph 8F, as in Frank. It says that buyer will be in default of this agreement if the buyer furnishes false information to anyone concerning buyer's financial and or employment status, fails to cooperate in good faith with processing a mortgage loan application. So if the buyer lies on this form and it lies on this form or to the mortgage, to the loan officer or the bank, then the seller and that loan is denied because that buyer provided false information, then the seller has justification for keeping the buyer's earnest money deposit. So make sure they are 100% truthful. Any questions, any comments? Because that's all I have.
Asked about the confidential agreement. I didn't see it in the GPAR forms. Is there one that we can pull from somewhere?
What was that again?
The confidentiality agreement, I put it in the chat.
Oh,
I didn't see it in the GPAR forms.
It's not there. You have to create one. I don't know if there's one in zip form. I don't know where, I think I have an attorney. I don't know where, if you can check zip forms. There may be one, I don't remember. I did that a long time ago. I only had to do that once. I don't know if I had an attorney draw it up for me or there was already one. I don't remember. But if you, yeah, I mean, you can probably have somebody draw it up or talk to your broker. Your broker could probably find you one.
Thanks.
Or any other questions, comments? You're welcome, Karen.
Good job, Trent. Thank you.
Thank
Was
you.
this helpful to you all?
Very helpful.
Yes, it
Thank
was
you.
helpful. Thank you for your time.
Another.
Great
Thank
job,
you.
Trent.
Thank you. All right.
Plenty
Well,
of
no-
notes. Plenty of notes.
What was that?
Plenty of notes.
Oh, good, good. Well, I wish you all the best. And Matt, I'll turn it back over to
All
you.
right. Trent, great job. Everybody else give him a round of applause. Thanks, Trent,
Amen.
for your wisdom and your time and all the prep that you do to make this happen. Again, guys, check out that Haven link, Fair Haven, for a refresher on fair housing. And with that, have a great weekend, everyone. Thanks for tuning in, and we'll see you on the next one next week. We're going to do home inspections. Take care, everyone.
Have
All
a
right,
good day.
goodbye.
Thank
Thank
you.
you.
You're welcome.